the directed verdict on counts 2, 3, and 4. I am going to reserve ruling on all 3 of those directed verdict motions on those counts. Mr. Bryan, I need to ask you some questions. Let me just swear you in. Do you swear or affirm that testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I do.
Okay. Are you Miles Bryant?
Yes, ma'am.
All right. Do you understand that you have a right to testify, and that if you want to testify, then no one can prevent you from doing so?
Yes, ma'am.
Do you understand that no one can make or compel you to testify?
Yes, ma'am.
Do you understand that you have the right to not testify if you do not want to?
Yes, ma'am.
Do you understand that it is your personal decision, not your lawyer's decision, whether you choose to testify or choose not to testify?
Yes, ma'am.
Do you understand that if you do not testify, I will instruct the jury that your decision cannot be used against you?
Yes, ma'am.
Are you aware that this is the only time you can testify during your trial?
Yes, ma'am.
Do you understand, sorry, are you aware that once the verdict comes back from the jury, you cannot change your mind about testifying? Okay. Do you understand if you choose to testify, you will be both examined by your attorney and the prosecutor?
Yes, ma'am.
Do you personally, Miles Bryant, want to testify or not?
No, ma'am.
Okay. I find that the defendant has freely and voluntarily decided not to testify with a complete understanding of his rights. All right. All right, y'all may be seated. We ready for the jury? Any matters?
I guess just a couple things. I'm just thinking through logistically here. Obviously, I don't know if the defense has any other evidence to present.
That was going to be my next question.
And whether or not, obviously if they do, it'll be their turn to present whatever evidence they want to. If they don't, and they also rest fairly quickly, contemporaneously with me resting, at that point, based on our discussion yesterday, I anticipate the court to
Release them. Release the jury.
release the jury. You reserve ruling on the motions for directed verdict. And then, so in terms of preparing for closing arguments to the jury, I got to have some kind of direction, I guess.
I will not be ruling until after the verdict comes in. All the charges will go to the jury.
Okay. So,
All charges will go to the jury as if I had denied
okay.
the defense motion.
So I understand exactly what the court's saying. I think procedurally and appropriately, the way to accomplish what the court is announcing is for the court to deny the motion for directed verdict at this time for the record, and then Ms. Drake can make a motion at the conclusion of the trial if any verdict is rendered, or if that's a guilty verdict, for essentially a judgment notwithstanding the verdict at that point, which is a renewed motion for a directed verdict, and the court can reconsider exactly what she's arguing at that time.
That's not my understanding of the law. I'm reserving ruling.
Okay. And I think you've announced what your intention is perfectly. I just wanted to...
I don't think procedurally I need to deny it.
Okay. So in terms of, if we get to closing arguments, I should and will be able to argue on all of the charges as lined out in the indictment.
Yes, all the charges will go to the jury.
Other than that, then, Judge, I do not believe that I have anything else. I'm ready for the jury.
Okay.
We're ready as well, Your Honor.
Okay.
And just for the court's planning purposes, I do plan to rest when the state calls.
Okay. All right. You'll bring the jury in. All right, we are ready. Good afternoon, ladies and gentlemen. Hope you had a good lunch. State, call its next witness.
Your Honor, the state has presented the evidence that we have, and we are resting.
Okay. All right. At this time, the state has rested. It is now the defense's time to present the case if they should want to. Defense call.
Thank you, Your Honor. On behalf of my client, Mr. Bryant, we are resting as well.
Okay. All right, ladies and gentlemen, at this time, I'm going to release you for the day. We have some issues we have to take up about the jury charges. And then tomorrow morning when you come in, evidence has been closed. That portion of the trial is closed. And you will hear closings from, or you may hear closings. The state and the defense will have opportunities to give what are called summations, which we talked about in the beginning, prior to commencing this trial. Let's go ahead and have you here at 8:45 so we can start at 9. We'll have any closings that either side wants to present. And then I will go over all the jury charges, which is the law that you are to apply to this case. I anticipate immediately after lunch that you will be beginning deliberations. It may be a little bit before lunch, but it's my guess is it'll probably be after lunch tomorrow. I want to remind you, you cannot look up this case, you cannot look up the defendant, you cannot look up any of the attorneys, you can't look up anything on the news about this case, on the internet, you can't post anything on social media, you can't talk to anyone about this case or talk to each other until we complete the trial, which will be tomorrow, and you receive it for deliberations. All right. See you tomorrow. Have a good afternoon off. Okay. We are off the record until Do y'all need any more time? I mean, I can step off 15, 20 minutes if you want to be here quietly in the courtroom.
I don't, Judge.
I think we're fine, Your Honor.
Okay, all right. Let's just start with page 1. State have any objections to page 1?
Page 1, Judge.
No objections.
Okay, page 2. I'm gonna call them out pages, then I want you to answer, okay? I know you want to take over, but I'm not gonna let you. Page 2. State have any objections?
Judge, I make the objection every time because case law has been consistent for 20 or 30 years that grave suspicion as a charge is not required when the court gives a full and complete charge on direct and circumstantial evidence and reasonable doubt. It is confusing. There's court cases on it. It's not, I mean, just to be honest with the court, I've never seen a case where it's error to give it. And so
Have you ever seen a case that it's error not to give it?
No, Judge. In fact, well, yes, if you didn't give a full and complete charge on direct and circumstantial evidence and reasonable doubt. If you didn't give those charges, then yes, it might be error. But the Supreme Court has ruled it is not error to not give grave suspicion if you give those other case. And the reasoning behind the Supreme Court's decision is that that charge is confusing. It muddles with the idea of reasonable doubt and direct and circumstantial evidence. And so it's unnecessary in any case. Although it's still in the pattern charges, and it's still requested in every case I've tried, and some courts have thrown it out, some courts have let it in. I always object because it's unnecessary and causes confusion. So I object to the grave suspicion charge.
Okay, Ms. Drake.
Your Honor, I specifically requested this, I think in this particular case, where there are other explanations for that the evidence suggests. I think it is very important in this case. It is still a pattern charge, and I'm asking the court to give it. And we're getting lots of other charges on issues that aren't really going to be argued. So I think to be complete, I would ask the court to give it.
All right, I'm going to come back to that. Other than grave suspicion, on page 2, anything else from the state?
No, Your Honor.
Defense?
No, ma'am.
Okay. All right. All right, page 3.
Your Honor,
Still-
I apologize.
That's okay.
I request what's listed in there under stipulations. I requested the defense. They denied that request to each and every stipulation. So there are no stipulations in this case. So everything under stipulations on page 3, 4, and 5, I believe needs to be removed.
I agree, Your Honor.
All right. I
had no other objections to that page 3.
Okay, so beginning at stipulations about 1/4 of the way down on page 3, we're going to strike stipulations. All of page 4 under stipulations, that's 5 through 13. And then the first 2 sentences on page 5. Is that correct, Mr. Delphont?
Yes, Your Honor.
Is that correct, Ms. Drake?
Yes, Your Honor.
Okay. All right, let's go to direct and circumstantial evidence on page 5.
No objection.
And I may be wrong, and I may be thinking about the wrong version. On the 3rd paragraph, because they recently updated some of the pattern requests to charge, and I did not know on the update if it removed circumstantial or direct, or if it was the other way around. I was thinking it had to authorize a conviction on circumstantial, maybe and or direct evidence, and then it finishes out the sentence.
Okay, so
And the only reason why I bring this up is
Right.
because when I pulled up the jury charges under Lexis, that's actually sometimes not the most recent version. And someone from the DA's office was gracious enough in another case to send me the most updated version. And I can double check.
well, we can double check right now.
I don't have my password. It won't pop up in here for sidebar, so I can either double check during a break or I can run out and get it now. I can't get into my pattern.
Well, you need to get into them, so
Yeah.
hold on just a second. We're having technical difficulties. Imagine that.
I have the pattern charges as well. I can tell you
Okay.
exactly what it says.
All right. Well, let's just, I'm going to just wait and let her get, we're having technical difficulties getting into the pattern charges. So just a moment. I'm sure that yours are the most updated, but let's just, I want to have her double check them.
I believe that this is the updated
Okay.
one.
I still, yeah.
And that, I think it's from 2022.
Okay.
So I just wanted to.
I understand, and Mr. Dillon has it too, so let me just trust but verify. Third
It's the
paragraph.
long version, right?
Yeah, and it's the third paragraph on direct and circumstantial on page
To
5.
authorize a conviction, right? Is that
Right.
what I'm looking
Right,
at? On circumstantial evidence.
comma, the proved facts. Okay. That is the most updated, and so that will be what's,
Your Honor, I would just ask the court to consider in the short version of the evidence, which basically tracks the same language, it, however, does have, you would be authorized to convict only if the evidence then brackets whether direct, circumstantial, or both. So I would just add that that verbiage from the short version be added to that paragraph. Because it is in the short version, it's just
But
not the long version.
it's not in the long version, the most updated.
Well, the short version is the most updated as well. There's
Oh, the short version.
Yeah, there's two different
Right.
ones. In the long version, it doesn't have the bracket that says whether direct, circumstantial, or both. The short version does. I would ask the court to just add that bracketed information into that paragraph.
There's absolutely No justification for that, no case law to support that. The two versions, while they cover the same topic, are written vastly different to communicate the same concept in two different ways. And so the inclusion of it in the first one, because it is a shorter version, compresses everything into a shorter span. It is fully explained in the long version. If that's the version the court gives, I don't believe it would be appropriate to inject a phrase into that just doesn't exist in the pattern charge.
Your Honor, I would ask the court to look at Mims versus the state at 264 Georgia 271, specifically at page 274. If the shorter version is making it more concise, then it would stand to reason that if something's missing out of the long version that's in the short version, it should be included in there as well. It covers all types of evidence, completely circumstantial, completely direct, or a combination thereof.
Okay, I want to make sure, does the state want the long version?
Yes, Your Honor.
Okay. Does the defense want the long version? Let's start there.
I like the short version. I think
Okay.
it's a lot shorter, and I think it's more direct and on point. And I'm not,
Okay.
I'm not,
Yeah, and I'm required to give the long version if either side requests it, the defense or the state. I'm not likely, I'll look at MEMS, but I'm not likely to change the most updated long version of this pattern charge and mix and match between the short and the long.
I understand that.
Okay. I mean, I will look at MEMS, but I doubt that I will be adding language to the pattern charge. All right. Anything else on page 5, Ms. Drake?
Oh, no, ma'am, thank you.
Okay. Page 6.
No objection, Your Honor.
Okay, no objection.
No objection.
Okay. Page 7. We may have to,
I don't believe under witness supported the character for truthfulness. I don't recall any testimony from any witness establishing character for truthfulness of anyone. Well, I mean, obviously, there's a defendant's
right. I don't think,
that calls into question his truthfulness in his statement, but not of a witness. So I don't think that that's necessary. And then lack of bias toward a party, I don't recall anything in terms of a lack of bias evidence being presented as to any witness. So I don't believe that the witness supported charge needs to be given.
okay. Ms.
I
Drake.
agree, Your Honor.
Okay. So we're going to take out witness supported. That is in the middle of page 7. That will be completely removed.
No other objections, Your Honor.
Okay.
Your Honor, I did not know, I don't know if I talked to the state about this beforehand. Under the bottom paragraph where it says witness impeached, we did introduce certified convictions. I didn't know if the court wanted to add that to the section that says witness impeached.
What are you asking to add in, Chris?
She would, you want to add this? Just do the pattern on the impeachment about prior convictions.
What charges?
Well, witness attacked has crime of dishonesty conviction. That's at the top of page 7.
Right, but any felony conviction can be used also as impeachment.
So what do you want in exactly, Ms. Drake?
Your Honor, as part of the pattern charge, there is a specifics that list out the different ways that you can impeach someone, just specifically the code section that deals with introducing a certified felony conviction.
I'm going to dishonesty.
Oh, I didn't want to interrupt.
No.
Judge, the pattern charge on witness impeach is 1.31.45. And it states in full, to impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified, or the credibility of a witness may be attacked by disproving the facts to which the witness testified. That's its entirety. There is no mention in that charge of any prior convictions of anyone, and I don't know of any other charge. Now, obviously, witness attack, the court has included that statement there.
Right.
It states what Ms. Drake is asking. I don't know what language specifically she's asking to include. It wasn't submitted as a request to charge the court, and I'd ask that it be formalized in writing, or at least an exact version of what she wants to add before we're just adding random words into the charge.
Your Honor, it's 1.31-40 under witness attacked. Here it's listed crime of dishonesty conviction. Right above that in the pattern, it says proof that the witness or defendant has been convicted of the offense of blank, listed in there. So it's
But it's
under witness attacked.
right, but it's under crime of dishonesty.
No, it's two separate sections.
Okay. Do you see what she's talking about?
So the felony conviction
Yes, and
portion is,
I can give,
Yeah, you need to file that in writing.
yeah, and I can give Ms. Hillary the specific conviction.
That's fine, but I want it filed in writing in the record,
Yes, ma'am.
and I'll look at it. And I'll resolve that one way or the other before we recess today. Okay? So, we'll come back, I'm gonna step off the bench on that one, well, on all of these, and we're gonna get you revised jury charges and go over them again, but on that one, I'll make a decision. Let's go on to page 8. Does the state have any objections?
Sorry, Judge, I'm catching up.
No, that's okay.
No, Your Honor.
Defense have any objection?
No, ma'am.
Well, I actually do, Your
Okay,
Honor.
all right.
Apologize.
That's okay.
I'm understanding throughout our motions hearings and the court's orders relates to the defendant's statements, the court has said in its pronouncements and called the interview a custodial statement or a custodial interrogation or interview. My argument then at the motions hearing, which continues until now, is that his the interview is non-custodial in its entirety. He is not in custody. He voluntarily came up to the police department. He even talks about in the interview, as soon as I leave here, we'll meet up. He firmly believes he's leaving. It's not until they tell him he's being arrested at the very conclusion of it and put him in handcuffs that he is not free to leave at that point. And so my argument is that none of those charges really are applicable because they all are predicated upon it being a custodial statement. I don't recall, honestly, Judge, off the top of my head, in your written order granting or denying the defendant's motion to suppress his statement, whether or not you called it a custodial statement or if that was your finding. I know you have orally said it on occasion. I don't know if that's the court's finding of it. My argument remains the same. It's a non-custodial interrogation.
And Your Honor, during the interview, he was read Miranda and specifically pointed out that he could not leave if he wanted to because he didn't know how to get out.
As I understand the state's position, you want me to take out the charge on statement of defendant and voluntariness defined and circumstances.
So,
Well, you want the whole, you want everything out?
No, Your Honor, I'm going to revise my request slightly.
Okay,
Despite whether or not it's a custodial interrogation, a custodial interview implicates only Miranda. But there are, and that's all that a custodial interview implicates. There are still, even when Miranda is not an issue, whether it's been read or not read, there are constitutional considerations in any statement, which are that has to be voluntary, regardless of whether it's custodial or not. And so I think to accomplish what I believe is accurate under the law, on the charge of statement of a defendant, then what I would ask the court is that you would get rid of everything from the fourth and fifth line of that charge, which states, and if the statement was given in custody, whether the defendant was properly advised of his or her constitutional rights. That would leave that charge to say that the jury must find, essentially, that the defendant's statement was voluntary. That's always the law. That's always the Constitution. It always has to be voluntary, and I don't think that's error to give that because that's a proper statement of the law. However, because I don't believe his statement was in any way custodial, it's not required to give Miranda, and the jury simply just, I don't believe, has to find that in order to consider the statement. The other charge, voluntariness defined, I think that's fine because it just talks about voluntariness in general, but without regard to Miranda or custody.
and all the circumstances, the statement, burden of proof, all of those in condition precedent.
Well, we hadn't gotten to that page yet. I didn't want to
Yeah, but,
get ahead.
okay.
As it relates to circumstances of the statement, I think that's fine. That's appropriate. And then burden of proof as to rights, I think that's fine. Conditions precedent to consideration of statement. I don't believe that that's necessary because that one talks about, again, him being advised of his constitutional rights, which are the Miranda warnings that are given. And so I do not believe that, because it talks about, if you fail to find the defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely. I mean, certainly Detective Carter read him his Miranda rights. It's not an issue about whether she did or didn't. But the charge is unnecessary because it deals with a custodial interrogation. And as a matter of law, the court can find it wasn't a custodial interrogation because that's your role, the legal aspects of it that are not before the jury. So I'd ask that the conditions precedent to considerations of statement and then the constitutional rights and burden of proof as to rights on page 10 are unnecessary as well.
Okay. So on page 8, you want the third and fourth line under statement of defendant removed, and then on page 9, you want the entire section conditions precedent to consideration of statement removed.
Yes, Your Honor. Conditions precedent to consideration of statement. Then on page 10, constitutional rights and burden of proof as to rights.
You want those?
I believe those are unnecessary if the court finds that it is not a custodial interview.
Okay. Ms. Drake.
Your Honor, I just think that because they did read Miranda after they chit-chatted for a while, the fact that she said, we know that you can't just get up and leave because you don't know where your way out, and also the body posturing during the actual interview itself was basically my client up against the wall and both of them right up there on him. That's an issue for the jury to decide.
I'm going to print my order. For the attorneys. From May 28th, I did not find in my written order that the interview was a custodial. All right. Deputy McCurdy, would you hand that to the attorneys? Thank you very much. After seeing that, any further argument?
Just only that, well, I understand Mr. Drake's contention that Miranda was read. That's not a triggering event. And the law is, under a totality of the circumstances, whether a reasonable person would have felt that they could leave. In this case, and in court recalls, we watched it again recently, the defendant, based on a totality of the circumstances, very clearly believes he can leave. Because he talks about he's going to leave. He talks about plans afterwards with people on the phone in the interview room during breaks. And so while there is a mention of Miranda, and it's actually read, it doesn't trigger anything legally. This court makes legal findings about whether it was custodial or not. If you find it's custodial, yes, it has to be given. All of it. Because it's a custodial interview. But if you don't find that, that's not for the jury's consideration. That's a legal conclusion that the court draws on motions and evidence to be presented. And based on your legal conclusions, the jury is charged on what they should consider. And so my belief is that because you have not found it was custodial and the facts don't show it, that it was custodial, those are not required to be given.
Ms. Drake?
I have nothing further, Your Honor.
Okay. And throughout this proceeding, I may have misspoken. I'm thinking that I had called it a custodial interview at some point. I think I do remember that.
Yes.
All right. I'm going to look at that and determine whether conditions precedent, constitutional rights, and burden of proof as to rights. So the bottom of page 9, the entirety of page 10, and then the last two statements under statement of defendant. And so I'll make a decision on those. All right, let's move on to page 11.
I think if we objected now, we're a little too late on that one. Because you've read it twice.
Three
no
times.
Objections, Your Honor.
I read it 3 times.
3 times.
I think I could have read it 4, but I read it 3. I was requested to read it 3 times.
No objection.
I have no objections.
Okay. Page 11. All right, what about page 12?
Judge, I don't have any specific objections to it. It is just very duplicative of the limiting instruction that you're already reading. Because the limiting instruction essentially tells them for what reasons they consider the evidence. And the charge on other crimes, wrongs, and acts on page 12. Yeah, so the limiting instruction, I said I don't have an objection to it, and I obviously didn't have an objection to its reading. I think that's proper. I'm not sure that because you're reading the other crimes, wrongs, and acts charge that the limiting instruction needs to be read at the conclusion of the case, because we're not presenting any evidence at that time. It was read before each presentation of that applicable evidence, and so I think that probably the easiest, most proper way is to remove the limiting instruction and to read the other acts instruction.
Okay. So we're going back to page 11, and the state wants me to remove all the limiting instructions that I have read 3 times.
I think that's what's proper, Judge, in terms of, because otherwise you're going to read 2 charges back to back with just slightly different language, and it's confusing.
I'll
Ms. Drake.
I'll leave that up to the court.
I mean, do you have any objection to me taking out the limiting instructions that I read during the trial?
No, because they are practically the teacher's orders.
Okay, so I'm going to take out page 11 and the top of page 12, which gets us to other crimes, wrongs, and acts. Any further objection to, on page 12, Mrs. Delphine? Okay, Mrs. Drake, okay. And page 13.
Your Honor, Ms. Matucci was bringing up a point on page 12 about other crimes, wrongs, or acts may be helpful, and that is that perhaps somewhere we should include that this evidence has, that they're considering maybe in the last paragraph on that page. So it says here, in the crimes chart, in the first sentence, the evidence may be considered only to the extent that it may show the element or issues that the state is required to prove in the crimes charged in the case now on trial. Instead of just simply that, we might want to include counts 1 through 4 in the case now on trial, because we did not tender any of that evidence to substantiate count 5, and the court did not order that any of the evidence was admissible as to count 5. So maybe just counts 1 through 4, if we insert that there.
In the other crimes, wrongs, and acts?
Yes, Your Honor. Just so that way there's no issue or error in the jury considering the evidence against count 5.
Ms. Drake?
So I understand, so the first sentence of that last paragraph, so it would basically read, the evidence may be considered only to the extent that blah, 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 to prove the crimes charged in counts 1 through 4, now on trial.
In the case now on trial.
Yeah.
Okay. And you consent to that, Ms. Drake?
Yes, ma'am.
Okay. That's in the limiting instructions that we just took out. So, all right. Okay, moving to page 13.
I have no objection necessarily to the way it's written. I'm not sure nobody's pointing the defendant out as the actual perpetrator of the crime. It was all digital. There are some witnesses who testified about encounters with him that night, like Ms. Parks and Ms. Smyer, but I don't know if anybody actually identified him in trial in terms of, I saw him do it. So I don't know that it's necessary, but if there's a request for it by the defense, I don't have an objection to it. I just don't know that it's necessary. But we really didn't have any particular issue with identification. It's always something the state has to prove. So, in that regard, I don't have an issue with it being offered. I just don't know that it's necessary. Witnesses did point him out in the courtroom, but just generally as to who he was as a person, he's Miles Bryant.
I think because they do have to prove ID, I think it would be appropriate to give it.
Yeah, I think it's appropriate to give it. I'm going to leave it
That's
in.
fine.
Page 14.
No objection, Your Honor.
No objection.
Page 15.
So Judge, in 15, just the crimes that are listed there are the incorrect crimes. Or not, they're not complete. So aggravated assault, home invasion are not charged in this case, so it just needs to be updated with the charges.
That's a problem. Where are we? Page 15?
Bottom, under knowledge.
At the very bottom.
Got it.
And it's my fault that's in there. Because
It's
that
okay.
was from a trial I did week before last, where Mr. Murray thought this was jury charge.
To be specific, Judge, we need to add malice murder,
Malice murder.
kidnapping, criminal attempt to commit rape,
Right.
and false report of crime.
Yeah.
And that's well. that same issue arises in the same charge as it continues on to page 16.
Okay. But page 15, other than changing the crimes in under knowledge, page 15, everything okay with the state?
Yes, Your Honor.
Everything okay with the defense?
Yes, ma'am.
Okay. And then 16, we need to change to the correct crimes at the top of page 16 in that first paragraph.
Yes, Your Honor.
Okay. Anything beginning at mere presence, guilty by?
No objection, Your Honor.
No objection, Your Honor.
Okay. Page 17.
Judge, just give me 1 second. I apologize.
No, you're fine.
Your Honor, I was just trying to review. I don't recall. I'm pulling up the indictment because I just don't remember if there was any conjunctive language. I would include that as a request, but I want to make sure that it's necessary.
I don't think there was.
Oh, there it is.
I can't find any, but you check.
Well, Judge, in count 3, it says that he did unlawfully abduct and steal away
Yeah, right.
Susana Morales without lawful authority or warrant. And so, because of those, I'll make
Okay.
my request for that charge just so that there's not an issue there.
That's fine.
And so no objections on page 17, Your Honor.
Ms. Drake?
No objections.
Page 18.
Your Honor, we're objecting to the inclusion of any lesser included offenses, including involuntary manslaughter. Just quite frankly, the defense didn't present any evidence that anything was done predicated upon any misdemeanor or any lawful act which resulted in the death of Susana Morales. Their request is essentially based on their belief that they can argue through the evidence that's presented, that they could argue possibilities of things that could have happened or might have happened, or maybe this happened or maybe that happened, all of which assume facts, not in evidence. The defendant could have taken the stand. He could have said it was an accident. He could have said it was reckless conduct on his part. He could have said it was contributing to delinquency of a minor, or any variety of misdemeanors and or lawful acts that resulted in her death. He chose not to do that. They chose not to present any evidence whatsoever, nor did they elicit through direct or cross-examination of any witness any other possibility that would support the inclusion of involuntary manslaughter as a lesser included offense. The case law is very clear that, one, there's a difference in involuntary manslaughter for felony murder and involuntary manslaughter for malice murder. They are separate crimes because the involuntary manslaughter on the malice murder requires intent, as does malice, and whereas the involuntary manslaughter on felony murder does not require intent. They are two different crimes, so even if given, it had to be given twice for both charges. But just frankly, Judge, and we knew this was coming. I mean, obviously, I knew she was going to make the request for it. It's the only chance her client has to avoid the significant crime. She mentioned it in opening, hold him responsible for something, for lesser, for what he did, but then there was no evidence to support that contention. And of course, what she says, what I say, is not evidence. Since there has been such a void of any evidence of any sort of misdemeanor committed by the defendant, I do not believe that any lesser included offense than involuntary manslaughter can be supported by the law. I know it's only slight evidence, but there is no evidence. So I object strenuously to the inclusion of involuntary manslaughter.
Ms. Drake?
Your Honor, I understand this position, but likewise, I can take the state's evidence, which has been presented to this jury, and argue what it potentially can show, just like they're taking the evidence and putting out their theory, as this is what happened. Any evidence whatsoever, it just has to be slight, and that charge has to be given, or the case is coming back. And I think that there is evidence, without going into what my closing is right now, that would support different possibilities of what occurred based upon the state's evidence. I don't have to present evidence to get a lesser included. If it's in the evidence itself, I'm able to argue that to the jury. They also have to disprove every other reasonable theory. And a reasonable theory could lead them to convict of manslaughter. So as opposed to arguing, just find him not guilty 100%, I'm going to ask the jury to consider this because they don't really know what happened. There is no direct evidence that he kidnapped her. Whether she was in the car or not, they don't know how she got in the car. And they're going to argue that, and we will argue it. But I think it's not going to be error to give it. I think it could be definitely error not to give it.
What's the slight evidence?
The slight evidence is that she used drugs, some of which only certain friend groups would know about. One drug in particular she did not know about. There is a video that was not played in the case, but only a snapshot was given of it. There is evidence, depending on how you perceive the Life 360, that says she leaves, but then she goes back to the apartment complex. There is evidence that Miles, on several, at least one occasion that we know of, offered her little friend group drugs. So she might have gone back there to smoke some more, or to get an edible, or to get another drug. But the fact that the state cannot show or disprove any of those as possibilities could lead the jury to believe that that is a reasonable theory, and as opposed to not asking for a straight not guilty, they could consider the charge of involuntary manslaughter. And the standard is slight evidence. It don't have to be compelling or overwhelming, just slight.
The only thing I'd like to say in furtherance of that, Judge, is that there is actual evidence in the record from the defendant's own mouth in his interview. He foreclosed everything she's saying. He said it wasn't an accident, it wasn't a drug overdose, it wasn't bad weed, she didn't try to rob me, I didn't find her dead, none of it. He said out of his own, that's actual evidence before the jury to consider. And there is zero evidence of anything else. They asked him every single one of those questions, and he said no to all of them. He stuck with it. There is no other evidence that anything else happened other than complete conjecture by the defendant. And so I understand slight evidence means slight, but no evidence. And in fact, there's evidence in the opposite direction that none of the things she just said are possibilities actually happened.
Your Honor, slight evidence is slight evidence. Now, can that be overcome during closing? Most certainly, and I'm sure that's what the state will do. But I get to argue other reasonable theories that they have not disproven. And if the jury finds one of those, it's either they're going to find him not guilty, or they'll have a lesser included to think of. I get to argue reasonable theories based upon the evidence in the case.
All right, I'm going to make a decision on that after I step off the bench. And also with, all right, so let's go on forward to page 19.
And while we're there, Your
Okay.
Honor, just based upon your decision, we did talk about this, and just where it is in the charge. If the court does decide to do that, I think it would need to come after the felony murder and not the malice.
Or read twice. or read twice, actually. Is that,
I think you're
Yeah.
correct, Judge. I
Yeah.
mean, and I'll just tell you, in terms of the case that's on point about that, because you may want to review it, it's Carter versus the state, 298 Georgia 867. It is a Supreme Court decision from 2016. And it just talks about that there's two different types of involuntary manslaughter as lesser included offenses, because both malice and felony murder are not created equal. They contain different factors and elements, and of course, I'll have to consider, depending on what the court rules upon, how I will respond to whether the instruction changes depending on the crime, because reckless conduct, which is one of the requested lesser included predicate offenses for involuntary manslaughter, requires no intent. It's a negligence. It's a criminal negligence, which is wholly separate and apart from malice. And so I don't think the court could give, as requested, a charge based on reckless conduct for malice murder. I think that's a legal error. The other predicate request is for contributing to the delinquency of a minor. Now, while neither one of those offenses, any evidence was presented on either one of them on the night that Susana Morales died, regardless of other incidents the defendant has been both reckless and contributing to the delinquency of a minor. I don't even know. I have to ponder that if the court admits it, but I think we'd have to tailor, should the court admit a lesser included, as to which offense you're admitting it to, and whether that changes between the two of them.
I understand your argument, and we'll come back to that. Okay, as far as page 19, felony murder and causation in felony murder, any issues?
No, Your Honor.
No, ma'am.
Okay, page 20, kidnapping and kidnapping with bodily injury.
So, I don't have any, I mean, they're both a pattern charge. I just don't think that, I think they can be combined. I don't think both of them need to be read. Kidnapping with bodily injury is how we accused it, or not accused it, indicted it. And actually, there is case law about charging elements or crimes that don't contain certain elements. If I charge it as kidnapping with bodily, I got to prove it as kidnapping with bodily. Unless I'm requesting a lesser included offense, which I'm not.
Okay.
I've not requested one. I don't know. I mean, to flip, but I don't believe that the defendant is either requesting kidnapping as a lesser included. And without that request, I think the kidnapping charge can be removed and it can just be read as kidnapping with bodily injury.
Okay. You agree with that, Ms. Drake?
Yes.
So I'm going to take out kidnapping in its entirety on page 20 and give kidnapping with bodily injury, bottom of 20 and next half of 21 in its entirety.
That's correct.
Okay.
Yes, ma'am.
All right. What about the remaining on 21?
No objection.
No objection.
Okay. And 22. Page 22.
No, Your Honor, no objection.
No objection.
Page 23.
No objection, Your Honor.
No objection. So depending on the court's ruling, we may have to tweak it.
Right. We are now on 24.
Judge, obviously, you object to the inclusion of any language that would authorize a jury to find guilty of a lesser included offense.
Okay.
So that specifically, there's a highlighted in red portion there that talks about a lesser included offense of involuntary manslaughter, so I object to that.
Other than the red portion with regard to involuntary manslaughter, either party have any other objections?
So, Judge, not an objection, but just a note that if you decide to allow involuntary manslaughter, I think you're going to have to duplicate essentially the red portion for the malice murder charge as well, which is currently not in there. And again, I guess that's really dependent upon what the defendant's request is. If they are asking for a lesser included offense on malice murder as well, and I'd have to look at their back there. I don't know if it specifies. But if they're requesting a lesser included offense as to malice, I think you'll have to duplicate that.
Yes, ma'am, I would agree. And I would be,
Requesting on both
Yes.
charges, on the malice and on the felony?
yes.
Okay. All right. Anything on page 25?
No, Your Honor.
No, ma'am.
Anything on page 26?
No, Your Honor.
Was that a no, Ms. Drake? I didn't hear you.
Yes.
You may have,
And I do have another request, Your Honor, since I wasn't sure at this point and had not anticipated it. First off, my office has filed the charge.
Thank you.
And I'm also asking her to file defendant not testifying, if that can be added.
I have no objection to the request. Obviously, if it's pattern, there's zero
Right.
objection.
right. It'll be the pattern. And I want to make sure before I leave. Okay. All right. Anything else before I step off the bench for a few minutes
Your Honor,
on the charges?
not on the charge. We were provided a verdict form.
Yeah, well, let me just,
Wanna wait on that?
yeah, let's wait on that because I got to make some decisions before we look at that. All right, so we'll stand in recess. Give me till 2:45, okay?
And Your Honor, if it becomes necessary, I know you've got some significant things to consider, particularly as it relates to the involuntary manslaughter charge. I'm also happy to submit to you and to Ms. Drake any supplemental case law or briefing that you want on the issue today, if you need that.
Okay, well, if I do, I'll ask you when I come back on the bench.
Yes, Your Honor.
Thank you.
And Your Honor, may I approach, please?
Absolutely.
I was just, well, I can wait whenever you leave the bench. I was just asking him if I could grab some of the exhibits to give the information to Ms. Krepusman on the certifieds that were entered, the charges.
Okay, that's fine. And I just realized that I did not go over the 2 bench conferences that we had today with Mr. Bryant. Mr. Bryant, we had 2 bench conferences. One was this morning. Ms. Drake needed a comfort break, and she approached to ask for a comfort break, which we took. And the second one was prior to lunch. I called the attorneys up and asked if the state was planning to rest after Detective Carter, and we discussed that. And Ms. Drake thought we should go ahead and complete and then let them go, but I wanted to give you over lunch to make sure that you had plenty of time to make the decision whether you wanted to testify or not. So I sent the jury to lunch, and so you'd have that extra hour, and then we reconvened, and state and the defense rest. And am I correct, Ms. Drake?
Yes, ma'am, thank you.
Am I correct, Mr. Delphont?
That's my recollection.
Thank you. Okay, I'll be back in about 15 till.